Trump slams Fani Willis, calling her actions egregious, in particular, her speech to the church, where she came out and called everybody on the other side a bunch of racists. And that was inappropriate for a prosecutor who's supposed to be fair, neutral, unbiased, nonpartisan, speak through their filings, not use the power of their office to go out there and slam defendants who don't have the same power. But she did that because she's Fani Willis, the biggest Fani in Georgia. Nobody can compete with her, clearly. So we're going to go through this because Trump replied to her, and this is about the motion to disqualify Fani and the motion to dismiss the case. And it's a big RICO case, 19 co-defendants, only I think 15 of them are remaining, but the idea is that they're all joining in on this. So the affair from Nathan and Fani has now been so uncovered that it warrants multiple co-defendants joining in. They all want their case dismissed because you can't hide it anymore. So Fani responded, and she does not want this hearing to happen. She does not want to debate any of this. Trump is saying the hearing has to stay on. Co-defendant Shafer also filed his motion joining the efforts, and we'll see what he said as well before we get reaction from Crazy Eyes and George Conway. But here is the filing. Donald Trump replies to Fani Willis's motion, and Fani is opposing Roman's motion and Cheely's motion and Trump's motion to dismiss this case and to disqualify DA Fani. And so Trump is only responding in kind of a narrow way. Remember, Fani's motion was big. She says, first of all, we didn't cohabitate and we never commingled funds. And we used our personal funds when we went to Napa Valley and on the Caribbean. And so, if we want to indict each other in our bedrooms, we're allowed to do that. But it doesn't impact the case. In other words, it's not material. And Trump says, hold on a minute. You called us racists. You went out to your congregation in Fulton County and said that we're racists. And that is inappropriate for a prosecutor because now you're tainting the jury pool and you're showing extreme prejudice in the case. So here is what Trump is responding to, because Fani wrote the big motion. We read it here. You can catch that in prior videos. But here he's saying, look, all right, President Trump, Your Honor, Judge McAfee, he files this reply to Fani's response. And specifically, he is replying in opposition to just this one limited section that Fani put in there. 1C of the responses on pages 17 through 18 says, first of all, this is Trump writing, the state, Fani, first claims that Fani's extrajudicial public comments, this is her church speech, in her well-publicized MLK holiday weekend church speech, she said in her filing to you, Judge, quote, neither referenced this case. She said, my speech didn't reference this case, and it didn't reference the defendants. I was talking about something else. Trump's people say nothing could be further from the truth, obviously. Says the DA, Fani, she said in pertinent part the following. We have a whole block quote here, so let's just read it, shall we? Fani's up at the podium. She says, why does Fulton County Commissioner Thorne and so many others, who's she talking about? Who could that be? Who's the subject? She says it wasn't the case or the defendant, so who? Why do so many others question my decision in special counsel? She says, Lord, you're flawed, hard-headed, and imperfect child. I'm a little confused, is what she said. Remember? I appointed 3 special counsel. And they insert themselves. They say, yeah, in this very case, which the DA now claims she did not reference, that's Trump's lawyer. Oops. She says, I appointed 3 special counsel. For what? What'd you appoint him there for, Fani? Oh yeah, the Trump RICO prosecution. So why did you then claim in your filing to the court, you can just make crap up in court filings as much as they like to. You can't. That's a lie or a fib, right? It's a for what? Hire 3 special counsel, a black guy, a white guy, and a white woman for some other case that we're not aware of? She says, as is my right to do. I pay them all the same hourly rate. But they, who's that? I wonder who that could be, Fani. They only attack one. I hired 1 white woman, says Fani, a good personal friend and a great lawyer. A superstar, I tell you. I hired 1 white man, brilliant, my friend, and a great lawyer. And I hired 1 black man, another superstar, a great friend and a great lawyer, and apparently a great lay, worth $1 million to her and the people of Georgia. Now, oh Lord, she says, they're going to be mad when I call them out on this nonsense. And remember, I'm pretty sure she didn't sleep with this white dude, which I'm still upset about. It's very discriminatory. But white woman, I don't know if she slept with him or this white man. That's the distinguishing feature. It's not the fact that they're black, which is racist for her to say, but that's how they interpret all this. Because they treat people like trading cards. It's disgusting. Says, first thing that they say, this is Fani, oh, she going to play the race card now. But no, God, isn't it them who's playing the race card when they only question one? Isn't it them playing the race card when they constantly think I need someone from some other jurisdiction in some other state to tell me how to do a job I've been doing for almost 30 years? God, why don't they look at themselves and just be honest? I mean, can't they, you can see all these are bolded out. They're like, who's she talking about? Who is this? Can't they keep it 100 with themselves, right? Come on. Why are they so surprised that a diverse team that I assembled, your child can accomplish extraordinary things. Yes, God, wasn't it them that attacked this lawyer of impeccable credentials, her man now? The black man I chose has been a judge, this is Nathan, here we go, for more than 10 years, huh? Run a private practice, more than 20 represented businesses and civil litigation. I ain't done. Y'all, he served as a prosecutor, a criminal defense lawyer, a special assistant attorney general, one chief justice, Robert Bayham Award from the State Bar of Georgia. You know, they, again, who is this? They ain't just giving this to black men. How come, God, the same black man I hired was acceptable when a Republican in another county hired him and paid him twice the rate? Oh, y'all ain't hear me, all right? In another county, the elected official has the authority to pay him twice the rate. Why is the white male Republican's judgment good enough, but the black female Democrats, not yet? I don't know who she's talking about if she's not talking about Trump or Trump's people, because they're the ones, okay, they filed this claim, Trump and these other co-defendants, including Mike Roman, saying that they are biased, and she's responding to them. That's who they is, the defendants. So they said, okay, we got that transcript from Atlanta News First, saying, now, a couple things here. In support of this motion, they say Trump also adopts the arguments made in Shafer's filing, which we're going to look at next, titled Motion to Disqualify DA Willis and her office from further prosecution. We're also adopting that. And also in Clark's filing, the motion to adopt as well. And tomorrow I'm anticipating we get to Clark's filing as well. But here is, they say, we're adopting those. Now, of course, at the end of this comment, they note Fani Willis diffidently, she neglected to mention, yeah, this is a great point, neglected. That's weird. Why didn't she's in the house of God. She's supposed to be honest about her past transgressions and her sins, but she neglected in front of his holiness. So neglected to mention that she only had an intimate personal relationship with the person she referred to as the black man, the only one, which is very racist, and not the white woman or the white man, who's Anna Cross and John Floyd, when she wrongfully accused them of playing the race card. She didn't sleep with the others, as far as we know. So they tell us. Now, the speech from Fani, she says she wasn't talking about us, but clearly she was. She referred to they and us all the time. Why are they coming at me? What do you mean they? They filed the motion to dismiss the case and disqualify the case. It's the only people who are coming at you. They're the ones raising the claim. Okay, so it's clearly them. But not only that, the speech was also made 6 days after they filed their motion. So the motion to dismiss comes in, Fani throws a hissy fit. She goes out in church, even though she was, technically the adulterer because he was still married. The speech was 2 days after the motion was brought up. She goes out, starts ranting and raving. So the speech was 2 days after the motion was brought up in open court on January 12th, and the court announced that an evidentiary hearing would be scheduled in February. The speech was also during MLK holiday weekend, where it's going to get maximum exposure. Now, Commissioner Thorne in minor part, but first and foremost, defendants through defense counsel, specifically Roman and others, this had led to the exposure of and the outcry about, right? They filed these motions, and there was a lot of outcry about an inappropriate relationship between Wade and Willis, in particular about the DA's improper hiring of Wade. Thus, who else would be the DA? Would the DA be repeatedly and predominantly referring to in her use of the words they and them? Like, this is kind of dry because they're like, clearly she's talking about them. Like, who else is she talking about? We filed the motions. She's responding to her being exposed by the motions. That's who we are. Who else could it be other than us? Now, those references are just as clear as the fact that her unnamed reference to the hired, quote, black man could only be Wade. There's no one else. From the day of the speech forward, not a single reporter, not a journalist, not a single media outlet has expressed the slightest bit of doubt that the DA's Fani's, that her racially invective comments were in direct response to Mike Roman's allegations in his court filing and were directed, she was responding to the defense counsel as well, saying, as this court is aware, even before the speech, Fani, in private emails to defense counsel on January 10th, had already gratuitously and falsely accused the defense counsel of racism, okay? So Fani is already crying racism. It's just, it's like, aren't you tired of that? Like, is everything racist to you? Okay, these are defense attorneys. You're the one banging your special prosecutor. Relax. So as the court is aware, right, she's already calling us racists for everything. I don't know what they did. Probably nothing. I'm sure it's nothing, right? Because it's Fani calling them racist. So clearly just throw that one right in the garbage. Oh, Fani said it? Okay, so forget it. Now, as one prominent commentator, this guy called Eli Honig said, he's a former, and he's not a like MAGA Trumper at all. He's a former federal and state prosecutor. He insightfully noted in an article in New Magazine's Intelligencer. He published this. He says, after these allegations surfaced, Willis somehow made it even worse. And we were watching this train wreck in real time. We're like, what is she doing? Prosecutors love to claim that we, quote, do our talking in court. court. They say that all the time. Oh, we'll let our filings do the speaking. And then Merrick Garland leaks everything to the Washington Post. Okay. Now, preferably accompanied, so he writes this, preferably accompanied by a dramatic lowering of the sunglasses. You know, we prefer to do our filings in the courtroom because prosecutors are so cool and hip. Give me a break. This is more than a catchphrase, he says. Okay, we don't just say it. It's an affirmation of the core duty to protect the defendant's liberty, which is true, right? The reason prosecutors, they have all the power in the first place. They have the charging power. They have the discovery power, right? They have all of the evidence in their refrigerators. You don't. They have all the money in the world. They have everything. Then they also have the power of the public speech, of the public, bully pulpit. So it's critical to the defendant's liberty. And his article goes on. It's critical to the integrity of our criminal process. Indeed, under the Georgia rules of professional conduct, he digs in, and pretty much every other professional code ever, prosecutors must, quote, refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused. Not supposed to do that. And it's in the rules. It's not like some blog post. But Willis did just that, says Eli. Days after Trump's co-defendant, Mike Roman, filed a motion relating to Wade, Willis responded not in a court filing, but she went in a speech. She went from the pulpit of the historic black church on MLK Day. The cameras were rolling. Willis told the assembled congregation and the general public, it was being live streamed all over the place, that the defendants had raised allegations about Wade, talking about her court case. Criminal defendants are entitled to make motions, by the way. He says, okay, like we're allowed to file. We're allowed to contest you, Fani. The fact that we say that you're dishonest and a liar, all these things, that's related to the defense of the case, okay? It's not because of your race. He says criminal defendants are entitled to make motions, by the way. Like we don't have to just sit there and just, okay, a black prosecutor indicted us. I guess that's the case. Case closed. Guilty, Your Honor. Fani's prosecuting me. But she says they raised allegations about this because of Wade's race, which is insane. Now, these public comments by DA attorney are anathema to the prosecutorial ethics and to fair practice. Willis, who is enormously popular in Fulton County for some reason, she received over 71% of the Democratic primary vote because you know how Democrats are, then ran unopposed in the general election. She publicly calls the defense teams in her highest profile case racists, publicly in front of everybody. What could outrage a potential jury pool more than that? Is there anything? Various judges have slapped pretrial gag orders on Trump and his other cases to prevent him from making inflammatory public statements outside of court that could prejudice the jury pool. But now Willis has done exactly that. And all the same people who cry about Trump every day on MS, silent, nothing. And Trump just actually calls out, the same type of stuff. He says, why is Judge Areola Engeron playing footsie with his court clerk, the principal law clerk on the same level who's ruling on every motion with him? Calling that out, they say, you're gagged. You can't talk about that. And then Engeron moved the cameras around because they're sick, right? That's actually what the First Amendment is about. Trump is a defendant. Trump is not a prosecutor. The defense has the right to free speech because that's the only power we have. Hello, we don't have the power of evidence because the evidence is in your refrigerator, government. We don't have the power of the money because you have it all because you just print it and shove it in your budgets. We have nothing. The only thing we have is free speech and the law, what's left of it. So it is to protect the defense, not the other side. So the gag orders against Trump are ridiculous and Willis can run free. And same with the DOJ, by the way, okay? They just don't file it because they're not morons, talk about it in public in their church proceedings, live stream to America because they think they're untouchable. I mean, the colossal arrogance of what is happening in this county is wild, but absolutely inappropriate. Double standards twice, right? Double standards both ways. So they say undersigned lead counsel can only hope that at the scheduled evidentiary hearing, which is scheduled for next week, which we cannot wait to cover, the DA will be required to explain in testimony under oath who else she was referring to as, quote, playing the race card. Okay, who else was this, Fani? If it wasn't Trump and our defense team and Roman's lawyers and everyone, who was it? If it wasn't the defense and the defense counsel. Saying, as this continues, now stated succinctly, Fani's position in its filed response is preposterous and it's disingenuous at best. And it's an outright lie at worst. It is an after-the-fact futile attempt to mislead this court. She knew what she said and she's trying to paper over it after the fact, and Judge, that is dishonest. Now, the state claims that Trump's motion to adopt and supplement raises vague and plaintive cries of due process. Nonsense. President Trump does not even mention due process in his motion. Idiots. This is just another instance of misrepresentation designed to delude this court. And we made this point when we were reading through Fani's motion. Like, they were talking about stuff nobody was even talking about. It's like, are you just trying to fill in the pages? Like, you're just trying to meet a page limit? Like, I remember that from high school and college. Like, I know what you're doing. All right. I was in law school too. We did that too there. Okay, go copy and paste some more case law. So what were you talking about? Due process. Well, he didn't even talk about it, weirdo. So for some unknown reason, yeah, see, same thing. The state's response talks about selective prosecution, voir dire, and change of venue. Now, like, the state must be confused. The threshold issues are disqualification of the DA and the dismissal of the case. That's what we're talking about. Remember, there was that one sentence in that weird motion I thought was written by an intern, but maybe that's an insult to interns. Maybe Fani wrote it. They were saying that the defense has no legal authority to pick their own prosecutors. And they cited case law for that. We said, what? Nobody's trying to pick their prosecutors. It's about disqualification of this prosecutor. So you're reframing the argument and then making arguments about an argument no one's making. They're just saying Fani's got to go because she's corrupt. And whatever you do after that's not our point. But they were arguing around the point. So they say, let's correct this, people. Maybe what Fani expects this court to do is to acquiesce in and accept at face value her proclamation that she is unlike all other prosecutors. And this is what we've been saying from day one. The biggest Fani in Georgia, right? She's not like other prosecutors. She's the biggest Fani. That this DA is somehow something special. That this DA must be treated differently, almost as though she's above the law. Now, that the ethical rules and laws simply don't apply to her. She can do whatever she wants. That this Fani alone can make prejudicial, out-of-court, racially partisan, and invidious statements about this case, and about defense counsel, and about the defendants like Donald Trump, whenever she pleases, in clear violation of her ethical duties as a prosecutor, and therefore that this court is now powerless to punish her by dismissal of the case and her disqualification, and instead may only seek to undo the substantial prejudice that she creates during jury selection? Such hubris, such self-consequence. She can go wreck everything and she'll fix it later, because if we dismiss the case, that's too offensive to the great Fani. The state knows better. The state knows that improper extrajudicial public comments by a prosecutor in the state of Georgia may be dealt with by disqualification. There's 1988 case law that supports it. The Supreme Court was asked to overturn a conviction because allegedly unethical extrajudicial statements by the prosecutor should have required his disqualifications. A prosecutor was running his mouth. Now, after discussing the ethical prohibitions against making extrajudicial statements, the court found that the prosecutor's public comment did not require disqualification. But in so holding, the court affirmatively signaled that if the improper out-of-court remarks by a prosecutor were, quote, egregious, right, that's the standard, then disqualification would be a remedy. So they're saying, yep, this is egregious. Here, Fani's conduct was indeed egregious. It was undeniably unethical. Her MLK holiday, quote, church speech intentionally and in bad faith injected race and religion and politics into the case, and it stoked racial animus by, among other statements, asking God why defense counsel and why defendants were questioning her conduct in hiring a black man, but not his white counterparts, and why the judgment of a black female, why, God, of a black female Democrat wasn't as good as a white male Republican. And she did so publicly, and did it to denounce and to rebuke defense counsel and the defendants for having the audacity to challenge her personal and her professional conduct, and to defend her public and political reputation against the allegations that Mike Roman made about her and Wade's indictments of each other. Now, the DA's provocative Fani and her inflammatory extrajudicial racial comments made in a widely publicized speech at a historical black church in Atlanta and cloaked in repeated references to why, God, it catalyzes the quintessential, the explicit appearance of impropriety regarding her prosecutorial judgment and her conduct. Now, as everyone involved in this case well knows, Judge McAfee, Trump's team writes, this is not the first time in this matter that Fani's incredibly poor judgment created an appearance of impropriety resulting in her disqualification. Now, Judge McBurney also took her to task during the special grand jury's investigation of the now Lieutenant Governor Burt Jones. Remember this? Fani held a fundraiser for his opponent for that position. Fani went out and campaigned against someone. Judge McBurney noted, says, the optics are horrific, and called it a what were you thinking moment. She thought, well, it's a blue county. I got elected by 71% of the vote. Who cares? Now, the present case is not a what you were thinking moment. It's far worse. Fani utterly failed to learn any lesson about unethical behavior from that prior incident. Instead, Willis made a calculated and a purposeful choice here to disregard her special ethical responsibilities as a prosecutor because she conceived it was in her own best interest to do so. Now, she must not be given a third opportunity, Your Honor, to flagrantly flout the rules to serve her own self-interest to the prejudice of her defendants. And her egregious misconduct demands the dismissal of the indictment, and it demands her disqualification and all of the other relief that we requested in this motion. Signed by Trump attorney Stephen Sadow in Georgia. served on the opposite parties as well. Very good motion, and I think it's obvious. You can see in the transcript itself, she was clearly talking about them, and it was a huge mistake for her to do that. But I don't think good lawyers, I don't think they really know what the law is or how it works all that well, which is why they've gotten 0 convictions out of this case so far, 4 diversion agreements, and they are on their heels on this thing. They've got a hearing coming up. They've got a bunch of subpoenas to Fulton County's office, which we're learning that is apparently being challenged now, but other co-defendants are joining in on the fun. This is David Shafer. He also is now moving to join, and Trump is joining his motion, and we'll see if the others do as well. But this is what this looks like. Defendant David Shafer submits this motion to disqualify Fani Willis and also the entire Fulton County office from prosecution in this case. And they also want an evidentiary hearing. So this is going to be the big issue now in the immediate future. In addition to just disqualification and dismissal, we have questions about whether the hearing is going to take place and whether certain people from Fulton County are going to be subpoenaed and actually show up, including Big Fani Willis and Nathan Wade. So here is the quote they start off with. It's a quote from Fani Willis. Very curious quote. Apparently, Fani said this to a reporter at the Washington Post back on November 14, 2023. This is curious. Fani says, quote, "If I were to comment on any open case, it would be a reason to conflict my office out." That's weird. Is that the same woman who gave a 30-minute speech at church talking about her case? Does she care what was happening there? Because that sounds like she knows you can't comment on an open case, you know? So why'd she do it for 30 minutes? Weird. Probably racism. Got her confused. But here, the Fulton County District Attorney, they say, by way of Mr. Shafer, she engaged in a pattern, they argue, of prosecutorial and forensic misconduct, which compels Fani from being disqualified, and not just her, but everybody, the entire office and their entire staff. Now, all the causes for this disqualification, they say, are self-inflicted blows, straying wildly from the legal guardrails, which are designed to protect the accused against wacky prosecutors. She, for over a year and a half, has given multiple interviews where she has improperly labeled the defendants fake electors. She's commented on the righteousness of her investigation, and she's shown a pattern of prejudicial public statements, including when she went to church. Let us set the stage here. First of all, in January, Mike Roman filed a motion to dismiss. He says that Fani began a romantic relationship with Nathan prior to hiring Mr. Wade. Okay, so Fani and Willis were apparently indicting each other in their judicial robes at a judicial conference back in 2019. Now, there's questions about this. Fani says, no, we weren't indicting each other before I hired him to indict Trump. Different type of indictment. But it's a question. Did she hire her lover, or did they form their loving relationship after he was hired? She says it was after, which maybe you excuse a little bit more. You're like, okay, they started working together and, you know, the heart's just, you can't fight love, my friends. Or did she want to give her lover a nice, cushy job so that he could divorce his wife and go on cruises with her? So scandalous. Anyways, under a limited contract with a cap on the amount, he billed like $600,000, estimates up through, you know, last year in the recent filings, $1 million. So they signed the contract on November 1st. The next day, Nathan Wade filed for divorce. Boom. One day after. See ya, honey. Nice 20 years with you. Have fun with the kids. In March 2022, Willis and Wade modified the initial services agreement. During that time, they continued their romantic relationship. They signed an extension of services that went through May 15, 2023. They continued their romantic relationship during these extensions. Just kept signing the contract. You know, hey, baby, we got to go on a cruise. Can you re-up my contract? She's like, sure, honey, I love that. Where are we going? Napa Valley? Yeah, I love it. So they say that while the filings in the divorce case were sealed, they went all over the place. Napa Valley, California, Florida, Caribbean. Wade purchased tickets for them on Norwegian and Royal Caribbean cruise lines. Golly! So rather than properly addressing the allegations, Fani, right, didn't respond through her filing. She went into church and she made offensive, incendiary allegations. She was playing the race card, which is the lethal third rail of American politics. Now, Shafer, and Trump is joining this, says the obvious intent of her remarks are to inject and to infect the jury pool in Fulton with unfounded accusations of racism, and saying as an attorney and as a prosecutor, her comments directly affected this pending litigation before us. And that constitutes high misconduct, forensic misconduct that warrants her removal from office. Now, also, if true, if what Roman submitted in his original filings making these allegations, if he establishes that there was a conflict of interest in hiring her romantic partner, causing him to be paid hundreds of thousands of dollars and then getting benefits on cruises and exotic destinations, but never telling the Fulton County Board of Commissioners about the nature of the relationship, that's a problem. In fact, rather than reveal and disclose her relationship with Wade, she chose to conceal affirmatively the existence existence of those personal benefits, and she failed to disclose the benefits and the gifts on her that was omitted from her financial disclosure reports. And we've got copies of those that we'll look at. Now, financial disclosure reports are required for a reason. It forces the public official to list any benefits that the office received from any prohibited sources, like Nathan Wade, who are doing business with the county, right? If you get a benefit from somebody, you gotta declare that. She instead chose to conceal the benefits. And let's take a quick look at that. This is a monster document, so we're gonna scroll all the way down and see what these look like. Here is one of her financial disclosures from Fani Willis. Here you go, 2021. Here, this applies to everybody. Do you have any income, Fani? Any income? Yes, Ross Law Firm, State Accounting Office, Fulton County, I got that. Consulting company, it's myself. She's not married. Fani doesn't have a spouse, so nothing there. She stole someone else's spouse, and so nothing's disclosed. A dividend income of $1,000 or more, nothing there. Hey, a gift, how about this? A single source in the aggregate of $100 or more. What is a prohibited source? It means any person, business, or entity that the involved officer or employee knows or should know is seeking official action from the county, is seeking to do business, or is doing business with the county. Bingo! Fani Wade is doing business with the county. If this person represents a person who is seeking official action or has interest that may be affected by the performance or non-performance of official duties. That's another one too, right? Is a registered lobbyist. So if any of these people are giving you anything special, you got to write it down. Got to write it down. Put it in there, Fani. Didn't do it. Has interest that may be affected by the performance or non-performance of official duties. Well, Nathan Wade's might, and Fani Willis's might, and they're transacting indictments, and they're also transacting, cruise ships, vacations. So she didn't declare it at all. And when she scrolls all the way down and look at this, she signed this on April 15, 2022. Fani Willis signed it right there. Big Fani of Georgia. Curious. No disclosures at all. And why is that? Because we know she got a lot of money from Wade. So as we go back to the argument, they say, additionally, pursuant to the Constitution of Georgia, Willis is a public officer. She is a trustee of the people. At all times, she's amenable to the people. Now, her conduct in hiring Wade caused hundreds of thousands of dollars to be paid to him, benefiting him personally, and failing to disclose her conduct is a clear breach of her fiduciary duty as a trustee to Fulton County. Now, pursuant to these facts and others, we now move for disqualification. We want her entire office gone. Her publicized statements have been severely prejudicial to the defense. And furthermore, Willis's employment of Wade to investigate and prosecute Trump and our clients, and payments to Wade of over $500,000, all while allowing Wade to pay for vacations for Fani and allowing him to pay other personal expenses for her, constitutes a disqualifying conflict of interest, and it's also a violation of ethical rules applicable under the law. Saying our clients, the defendants, Trump and others, here Shafer, says we possess a due process right to a fair trial. We do not want to have an impartial jury who thinks we're racist. We deserve to have a disinterested prosecutor who's interested in doing justice, not interested in funneling cruise money to her lover. The court furthermore possesses duties to ensure that we do get that fair trial, that we do get an impartial jury, and that public confidence is preserved in the impartiality of the administration of justice. But here, Fani's improper prejudicial actions, which are intentional, she did this, these are self-inflicted wounds, it warrants her disqualification, and it must be done to vindicate our rights and to restore the appearance of impartiality, which I completely agree with. Now, they give us some background. They say that Fani played the race card. She made statements to the news media trying to inject race into it. And they also recap her Georgia church speech, which we'll fast forward through because we read that previously. And they give the full comment, right? The full thing, much more than we read. Now, as she knew that they would be after that big long speech, her statements were spread all over the place. And irrespective of her vagueness as to whom her statements were directed to, it's plain they were talking about Roman. Now, there were a flood of media stories that hit. They all came out. The media correctly understood that Willis was accusing her defendants of racism. They all reported accordingly. But then we have some other quotes. She made other statements. She called us fake electors, right? She called us fake electors. She said the fake electors, she was already commenting on this case. And all of these are headlines and stories. Now then, apparently there was also a book that she spoke to. Willis knew that this book that was featuring her as a hard-charging, afraid-of-nothing prosecutor would get extensive publication prior to the trial. She gave a bunch of interviews and she gave conversations about racism. And she told the authors that since her office opened this RICO case, that they'd gotten a lot of comments. The comments were always racist. We have to live by certain standards. If you violate them, you catch a charge. So they say, look, all of this requires Fani to be disqualified. Lots of rules here they're going through all the rules in Georgia, explaining what the rules say and why she's got to go. DA Willis publicized statements. It suggested that everyone else is motivated by race. She called everyone else racists. And the rules of professional conduct say you're not supposed to prejudice a jury panel like you're doing here, talking about black man and white woman and so on. But they paid a lot of money. Willis failed to mention that they had a romantic relationship. And there is no evidence whatsoever that Willis did indict the white guy. No one knew that. Caused several hundreds of dollars, thousands of dollars to be paid to the white guy. Did the white guy ever get personal gifts? Did he go on airline flights? Did he get seat upgrades? Did he get hotel stays with Fani? Did the white guy get ocean cruises or wine country tours or beach vacations? No, he didn't. Thanks, Fani. And then they failed to report those gifts on her financial disclosure forms. Now, sadly, it is Willis who is playing the race card, and the Supreme Court has said that's not appropriate. But here, Willis has willfully and publicly raised racial arguments relating to the issues of this action, and that disqualifies her. Even the rules of professional conduct say you can't do this. The jury is supposed to be our protection of life and liberty against race or color prejudice. The jury is supposed to clear that out. But here, she's making it a primary thing. Her deliberate and inflammatory accusations at the Atlanta church that those objecting to her employment and compensation are racist, that is forensic misconduct, and it warrants her removal. Willis repeatedly emphasized and contrasted the special counsel Wade's, his race against the others. The DA's public appeals were literally based on bias and prejudice. Oh my God, she says, you forgot to mention that my life and the life of my family would be threatened so regularly. She improperly injected religion into this case, right? Talking about God all the time, saying that God had qualified her, that she's allegedly doing God's work. Totally inappropriate. So I guess if you don't vote in favor of conviction in Fani's courtroom, you're going against God. Her statement concerning her superstar team was vouching for the prosecution. She's talking up her case. Now, given their conviction rate, potential jurors would assume that defendants are guilty, given that prosecutors win 95% of its cases. Now, Willis also made inaccurate characterizations of Mr. Shafer, calling him fake electors, right? Prejudicing the media with that. They say, no, sorry. Mr. Shafer was acting pursuant to federal law in the Constitution. He was following the advice of his lawyers. He and other nominees were following the literal precedent. We've talked about this many times. The 1960 presidential election in the state of Hawaii, which was JFK versus Nixon, I believe. Shafer and the other 2020 Republican presidential electors were not fake electors. And that type of commentary has greatly prejudiced Mr. Shafer, saying that all that was part of a calculated plan. She's making intentional and prejudicial public statements. And so the court needs to step in to protect the defendant's rights, saying there is a serious conflict of interest here. Willis and Wade, she paid him 3 times more than her annual salary, okay? She paid him money that she could not get. And then she got those gifts, and she was privately involved in a romantic relationship with him as well. That is an actual, substantial conflict of interest. They say now her hypocrisy in having a romantic relationship with Wade while criticizing Paul Howard for having his improper relationships is astonishing, right? And she did that. She got elected on that. I'm not going to sleep with my employees, and I'm not going to steal any money. Oops, wrong on both accounts. Now, Willis is causing over $500,000 in county funds to be paid to her boyfriend. Oh, I love they use that word. I hope you enjoy your boyfriend and her receipt of gifts from Mr. Wade in the form of expensive trips. That is not in the interest of the state. Okay, Georgia doesn't care about these two lovebirds. Maybe they do. Willis, furthermore, presumably possesses a personal interest in her romantic interest, obviously, and Wade is continuing to get a large amount of money so they can go on vacation. Now, Willis knew what she was doing was wrong. She herself made accusations against the prior guy, him indicting his employees, saying we have a right to disinterested, conflict-free prosecutors, not Fani and Wade. Now, their financial conflict is also a big problem. She's supposed to impartially discharge her duties, but her conduct in employing her boyfriend, there it is again, at a cost of over $500,000 while not disclosing any of this stuff is inappropriate. Other county attorneys have been indicted for stuff like this. This guy got thousands of dollars from a defendant in exchange for not prosecuting. All right, that's a little different. But here, the defense has also gotten Fulton County disclosure reports that we read through. Fani didn't disclose anything. Willis did not disclose any of the gifts that she got in her disclosure report. And we have other cases where that's a pretty big problem. Other people had relationships with lobbyists and stuff, and they did not disclose it. Now, her failure to list these gifts may reasonably be found to constitute evidence of intent, on the part of Fani. Intent to conceal the gifts. We got a mens rea right there. What is your mindset? And we have an actus reus. We have an action. That's a crime. Mental state, mindset asset plus an action, they're talking about criminal charges here. The prosecution's opposition doesn't address this at all, fails to address this. So they didn't say maybe they could charge her with a crime, but that's what they're saying, right? Maybe she did commit a crime. I don't know. We'll have to see. Willis and her actions are already under investigation by the Judiciary Committee and Georgia. And in light of her conduct, we're concerned about this, the potential consequences. What happens if there's a Republican administration in charge of the DOJ? Maybe she gets prosecuted. Now, her conduct constituted a clear breach of trust. Georgia says you can't do that. You have a fiduciary duty. Fani breached those duties. Hundreds of thousands of dollars got shifted over to her boyfriend. And she also didn't get proper authorization from Fulton County to employ him in the first place. Georgia law says you have to do certain things, and he didn't. And also, the code of ethics are critical to the proper functioning of our government. Willis violated these provisions. Undisclosed romantic relationship, hundreds of thousands of dollars. She got trips and vacations, and she violated her fiduciary duties. Now, all of this is earned. She earned it. She earned the disqualification of both herself and Wade. Her personal conflicts, her financial conflicts, her dereliction of the law, her duties of trust, her ethical rules, all breached. And a consequence, she made prejudicial statements in the aftermath. She did all the bad things, and then she talked about it and blamed everyone else for it. There's a quote that says, "The administration of the law, and especially that of the criminal law, should, like Caesar's wife, be above suspicion and should be free from all temptation, bias, or prejudice, so far as it is possible for our courts to accomplish." And Fani has wrecked all of that. And so the disqualification of Fani means the entire office has to go. Fani's the head dog. She's the biggest Fani in Georgia. So if she's gone, the rest got to go. Saying here, we need an evidentiary hearing. And this is the main point. Fani does not want this to happen at all. Saying an evidentiary hearing is necessary on our disqualification motions. We have facts in dispute. We need to get to the bottom of this. Nathan said they started a relationship after they met at the judicial conference. Witnesses say no. Witnesses say they got a little judicially on each other. You know what I mean? And the prosecution's opposition to the motion to dismiss attaches a declaration of Mr. Wade. He swears his personal relationship with Willis began after he got hired. But there's no declaration or affidavit from Willis, however. The filing was filed in her name as the DA. Now, of course, she cannot file such a filing if she knows it contains materially false statements. Exactly right. Willis's office endorsed that affidavit. She's saying that too. They don't know that we really met at the conference. They don't know any of that. Yeah, they do. Mr. Roman's reply filed on February 2nd represents that several witnesses will directly refute Mr. Wade's declaration. We saw you two at the bar, okay? We know what was going on there. You were not talking about judicial code of conduct, clearly. If the testimony of these witnesses proves credible, the inexorable conclusion would be that Mr. Wade has made false statements and lied in his declaration, which has been filed by Fani herself. They're going to get caught in a cover-up on her behalf in the records in this case. This is why we need to have this hearing and why we really want the judge to make sure it stays, which would constitute yet another instance of forensic misconduct. Now, additionally, Mr. Wade declares that the expenses for personal travel were roughly divided between Wade and Willis. Now, presently, the public filings in the Wade divorce proceeding and the, quote, example of Willis purchasing tickets for herself and Mr. Wade are not roughly equal, all right? We don't think that they split things evenly. An evidentiary hearing is necessary to obtain the complete financial picture of the gifts and the benefits that Wade gave to Willis. Saying a full evidentiary hearing on the motions to disqualify Fani and Wade and the entire office is really needed to obtain true transparency. The rules say that motions shall be heard at a time, and an evidentiary hearing would permit the defense to develop the evidence that relates to disqualification. So the court should allow a full evidentiary hearing to happen on February 15th, the day after Valentine's Day, which is just great. So when these two little lovebirds are on, whatever lakeside steakhouse they're at, indulging on the dollar dime of Fulton County, they got court the next day. Now, counsel understands and appreciates that an evidentiary hearing about the DA's forensic misconduct and their personal relationships that creates these conflicts is unseemly. Okay, this is like a big problem. Like the judge is like, oh gosh, it is unseemly. They acknowledge it is an uncomfortable experience for all involved. Counsel does not pursue these claims lightly. Okay, and I agree with this. We're having like some fun with this because it's so fantastical. It's like, what on earth? They indicted each other, went to Napa Valley and cruises, and then she billed for that, and they were banging each other at a judicial. What is going on? But like for the actual people involved in this, like it is uncomfortable. If you're in the courtroom, if you're the attorneys litigating this, you're like, oh my gosh, we got to talk about you two, in a professional courtroom. Like, okay, we got to talk about you two doing this stuff. Let's go. We got to do it. Let's get to it. So it is uncomfortable, but such is the law. But as noted, DA Willis and Mr. Wade are not the victims here. That's exactly the point. Sorry it's uncomfortable for you. These are all self-inflicted, completely avoidable errors in which the defense had no hand, and so the defendants cannot be prejudiced by your philandering. Of such significance, the defense had no choice but to put them before the court. And shout out to these defense attorneys for doing it, because she is the biggest Fani in Georgia, okay? And if she's corrupt in this area, where else is she corrupt? And the big picture here, this discomfort, it pales in comparison to what Mr. Shafer, the defendant, presumptively, under our old rules where we used to have the presumption of innocence, remember that? And an actually innocent man has endured. His life has been upended by unwarranted and meritless charges filed by Fani that she does not even have the legal authority or the jurisdiction to pursue. Mr. Shafer, my client, obeyed the law. He followed explicit, detailed, oral, and written legal advice by no less than 5 learned and reputable attorneys. Could you imagine that? And the only existing American precedent. So he now finds his liberty and his livelihood threatened by powerful levers of law enforcement that have been improperly weaponized against him. Through her extrajudicial and prejudicial statements, DA Willis has further weaponized the media, the public, and now even the church. An evidentiary hearing on the matter set forth in the disqualification motions is critical for the parties, and the court needs to have sufficient information to understand the full nature of Willis and Wade's misconduct and their conflicts to assure that an impartial administration of justice that's promised to every American citizen is afforded to those accused of crimes. And so, based upon all of the foregoing and all of the authorities, we now, David Shafer, through his counsel, respectfully request that Fani be disqualified along with her entire office, and she goes away. Her office disqualified from representing Georgia. Great motion submitted by Craig Gillen. Shout out to Craig Gillen and Holly Pearson, extraordinary defense attorneys standing in the breach on this very, very complex case and Fani scandal. So that is what they submitted, and we have the hearing on the 15th, so make sure you are subscribed. We cannot wait to unpack that one when it happens. But one issue that we're talking about that might really make a lot of this moot is immunity, presidential immunity. And previously, we talked about the Supreme Court opinions, or the DC Circuit Court of Appeal opinion that came back down, which is likely going to go back up to the Supreme Court. And that DC Circuit opinion we read through here on a prior channel. If Trump has immunity, there is maybe some good argument that the federal supremacy clause, if he has federal immunity, might supplant Fani Willis's case, right? So the Georgia case might go away. So when Trump appeals the immunity decision, we'll see what the Supreme Court does on this. But we read through the opinion and we kind of thought it was like a blog post in many ways. It was a lot of copy and pasting, which is what a lot of blogging is. And it was a lot of very short analysis with contorted conclusions. And so it didn't seem that articulate to us. We read through it. We even saw logical inconsistencies, like where they would say and make the argument that Trump was arguing for absolute immunity, but they would frame it in a way that was not what his actual argument was. So it was them arguing around the point. We had many, I thought, valid criticisms of this opinion, but apparently we were wrong. George Conway, the guy who introduced Roberta Kaplan to E. Jean Carroll and set up that whole lawfare situation, the same guy who got divorced by Kellyanne Conway, is a rabid anti-Trumper now. He goes to parties with Molly Jong-Fast and they celebrate Trump prosecutions all the time. And so here is George. I think he is wearing a cheerleader skirt underneath this, right? You can't see below the chyron there, but he must have some pom-poms or something because, man, he is cheering away for this opinion out of the DC Circuit.
It was masterful because it combined so many elements. It combined constitutional text, judicial precedent, history, and just sheer logic, and the party's own concessions, Trump's own concessions, to make just an absolutely cohesive whole opinion that is just inexorably leads you to the conclusion that he is not immune. And it was just so well done. And it also, one other aspect of the decision, which makes it even more bulletproof, is the fact that they narrowly focused on the exact situation in this case. They weighed the potential costs of not having immunity, which is what Trump talked about, which is the danger of a floodgate of litigation, of criminal litigation, which they poo-pooed. And they matched it up against, as they were required to do by the immunity case law, they matched it up against the public interest. And the public interest wasn't just the public interest in the enforcement generally of the criminal law, but this was the public's interest in constitutional democracy and in the peaceful transition of power. And when you weigh the two up against each other, there's just no question.
Okay, so you see that analysis there? Great analysis. So the public interest is just so heavily weighted in favor of doing what they had to do, which was to deny Trump immunity, that the law didn't even really matter. It's just, don't have to really talk about it all that much because they weighed the immunity considerations about public interest. And they did that in a case that was very narrowly tailored only to this defendant, which is Trump. And then they were so cowardly that they couldn't even sign their names to it because they knew that this was a garbage opinion, as he says. But what, right? That was as fluffy as it gets, enough already. But here's this next question about what should the Supreme Court do about this?
So the real question here is, how does the Supreme Court read this? Because Trump's team says they do plan to appeal it. I mean, you say that it doesn't require further review.
Yeah, it doesn't, because this opinion is so good and so clear, so comprehensive. There's nothing in it that could be possibly attacked. Yeah. And I don't see how even the Supreme Court could write, I don't see how any judge, any court, anywhere, including the Supreme Court, could write a better opinion that more accurately states what the law is and should be. And as a result, I don't think it's worth the court's time to deal with it at this point.
Yeah, forget it. You guys got so much other things to worry about. It's just one of the biggest, most important cases in American history. It's not worth it. It's too perfect.
If Trump is convicted, which I think he will be, they can actually review this after his conviction. And meanwhile, the Supreme Court already has its hands full. On Thursday, it's going to hear the argument in the disqualification case from Colorado, where the court in Colorado held that Trump couldn't be on the ballot because he was an insurrectionist.
Yeah. So, I mean, we don't know what they're going to do, but let's say that the Supreme Court does take it up. Given all of the arguments that Trump's attorney made were totally eviscerated by this court today, is there a new legal argument that they could make to the Supreme Court here?
No, because they threw everything up in the air, and every single argument was methodically and systematically dismantled by this court.
They're not even saying anything, okay? They're just talking like, people who don't know what they're talking about are talking. Is there anything else he can do? No, he's done. It's done for. Are you sure? Yeah, definitely done. Sure. All right, so that's how they talk, okay? And that's their analysis on CNN. I just wanted to share that with you. And then this is another person who is also brought out on the media shows. Of course, Crazy Eyes Griswold was on MSNBC's hit show called Inside Jen Psaki. They are big friends. They love having Griswold on. And she came on to talk about her death threats and how scared she is and why one political party is responsible for all of the harm. And I gotta keep emphasizing this point. She is the scoreboard manager. She is the Secretary of State. These are the people who are counting the ballots, right? Now, she's not, explicitly doing that, not literally, but her office is, right? The people who are working under her, the little procedural mechanisms that change up, that might impact red counties more than other counties, they're all, governed by this person. And she is just a carbon copy cutout of the same secretaries that we have in many other locations, like Michigan with Jocelyn Benson, like we have in Maine with Shenna Bellows. And it's just a repeat thing everywhere we go. But how can anybody in Colorado, after listening to this woman, believe that their elections that are run by this woman are free and fair?
Let me ask you about threats. You just raised it. I mean, last month, Donald Trump warned of chaos and bedlam if other states followed Colorado's lead. In terms of threats, are you concerned about your own personal safety?
Yes, I've been concerned about my safety since 2021 when the threats started to roll in. When this case was filed back in September, within 3 weeks of it being filed, I had 64 death threats. We're seeing the extreme right use threats to intimidate election workers and secretaries of state. It just shows what is on the line. If a political party is trying to cheat, steal, or intimidate, there are major problems with that party. They are dangerous to American democracy. But just like your prior host said, I won't be intimidated. We cannot be intimidated. In the fact that Donald Trump had the audacity to say there would be bedlam and chaos to the United States Supreme Court, depending on their decision, just reeks a low-grade threat to me, given his track record.
You see those eyes, man, are like extra levels of crazy right there. Like right there. Oh, yeah, right there. Whoa. Okay, be careful. All right, so as you can see, she is running the scoreboard. She is counting the votes, and she is very, very rabid against anti-Trumpers. And by the way, I don't support any death threats at all, okay? Nothing even remotely close to that. Why? Because it's illegal. You're not allowed to do that. You can't threaten and harass people. It's illegal. So imagining that there are 64 criminal charges or investigations that were looked into about those claims. Were they legitimate threats? Were they just, comments? What is she talking about? I know everyone's under attack all the time now. I got it. And they can use that now as we're under attack. Therefore, I'm not going to be intimidated. Therefore, I'm going to go wage war against MAGA. You're the Secretary of State. You run a pretty complicated thing. You're trying to disenfranchise half of your state. People are going to be upset about that. So that doesn't give you carte blanche to go after the opposition and now become a partisan, weaponized person. But of course, that's what she is. And that's what they sound like. So her and Conway probably shop at the same stores and hang out with the same people, but that's what they're willing to do. And so we're going to continue to cover the Fulton County saga. We're going to come back and read Jeffrey Clark, and we'll see what Fani's response is, because she's now trying to quash the warrants, quash the subpoenas for the evidentiary hearing that is coming up next week. week, and we're going to be covering that one in depth. So make sure you're subscribed wherever it is you're watching this, my friends. Thanks for checking out robertgovea.com if you want to read any of the PDFs that we went through. We also have watcherlodge.com, which is now available. So you can go to watcherlodge.com and grab our latest Survival Squad masterclass that we just did, and it's going to be available there. You can get a PDF, free downloads, and free templates for building your survival squad at watcherlodge.com. Links are down below. So check that out, my friends, and we'll be back here with you on the next one.